Hi, Cora Stack again. I just wanted to get back to that previous point. I have more clarity on it now. It's like, having a really difficult mathematical question and you have to, your exam is very shortly, and if you don't figure it out, you won't, get first place or a medal in your degree, so, or a faculty prize, that kind of thing. So that's never what I worked for. I always try to solve the problem, the challenge. So, but getting the prize, getting the faculty prize in mathematics at a time when no female got it was, from someone from North Kerry was phenomenal. So, a constitutional question that cannot be ignored. I want to, and of course, getting the Global Award this year for excellence in academia and education from India in honour of a Nobel laureate, and there's a huge amount of talk about him. Rachmaninoff, Ramanujan. That was phenomenal. I was the first Irish recipient, and it really, I suppose, it really has helped me kind of reaffirm my belief in myself, because women get a hard time, get a very hard time, and that hasn't changed much, if you ask me. It just the complexion has changed. But, anyway, we're slowly beginning to rise, but we have a lot more to do. So I want to speak directly about a constitutional issue that has wider constitutions in any single election. So I have more clarity. It's like the problem has been clarified a little bit more. So we could say it's a constitutional question that cannot be ignored or should not be ignored. And I have to put it in perhaps this way in order for it to be understood by the readers. And if anyone has a solution, put it down on paper. I'll be delighted to acknowledge it in further correspondence. And I'm so pleased with the level of engagement from the vast majority of the the respondents. They're brilliant, really. The vast majority are brilliant. There are one or two who are are very destructive and are kind of harassing me, but I've reported them repeatedly. But this is always happens, and most people have people to to filter these people out. But the vast majority of people have engaged very constructively with this really complex. It's really complex. This isn't a simple YouTube channel. It's for it addresses very complex issues, so it might appeal to everybody. But anyway, look, it's been a great opportunity for me to clarify my own thinking. So as you would really when you're in a lecture, sometimes the students raise you up. They make you go beyond your level. So it's like that. So, but using a collaborative approach. So the issue arises from the presidential nomination process, and in particular from what is known as the people's route to nomination. The route exists in the Constitution, Irish Constitution, more often here, so that candidates can come forward without relying on political parties. In theory, it is meant to be a real and functioning pathway, not a theoretical one. And again, I said it was all about checks and balances between party control and people control, which is essential in a functioning democracy. It is absolutely critical, or otherwise you end up in a dictatorship, which a lot of people have been saying. What democracy? What democracy? I mean, that was made very clear earlier on in one of my first videos, and somebody kept saying, what democracy? What democracy? And it really, got me thinking. So it was a very, I could see the pain in this question and the truth of it and what it was expressing. So that really has spurred me on to all of this, and I have to thank the contributor hugely. So and all the other contributors. In the most recent nomination process, it became clear only after the process had ended that no candidate had come through the people's route. The reason was not public rejection. In my opinion, it's very clear. The reason was the route itself had been blocked at the level of nominations. This is where the constitutional problem begins. The full impact of what happened could not have been seen while the process was ongoing. And once the impact became clear, the process was already closed. There was no clear legal point at that stage at which the issue could be examined or decided. This raises a serious question for the rule of law. This is the issue. I probably need further clarification, but can a constitutional system function properly if a constitutional breach can occur but cannot be examined at any stage when it becomes legally visible. In particular, that was the point I was making, that Mr. Nyberg and myself brought two constitutional cases when we could bring them. Once it was clear that that there was a problem, a potential serious constitutional problem affecting the human rights, the Constitution, that there was breaching the Constitution. One was that the nomination process was interfered with, and that was that it was genuinely interfered with, but through a party directive which occurred after the presidential order was issued, and that this was not. It had a huge influence on the outcome, so it interfered materially, statistically, probabilistic, mathematically, with the outcome. Second, then, consequential on that was the problem: could if that's unlawful, or if that is unconstitutional, as we believe it is, breaches Article 12 or a number of articles. That's the most powerful one. That one, Article 12, is by far the most powerful one here. Is the one that really needs attention. What is the consequences for the lawfulness of the election process if that is proved to be unlawful? The first one. Now, that we were not allowed through, I believe, what was reframing strategies to address either before the election, and really the time frame was so tight it would have been very hard to bring it to appeal if the High Court did not agree with us, which they didn't. They kind of skirted around the issues, which is not unique to Ireland, but it's going on. This reframing alleged of getting around the problem by saying they're either personal grievances or they're non-justicable, and therefore shutting the constitutional challenge out. And then our cases were brought forward right to mine was to the eve of the election, and Mr. Byrne was almost behind me at that stage, the day before, 2 days before. And his judgment was integrated into mine, which made mine catastrophically wrong, inverted commas, without that judgment having gone to the appellate court for further adjudication, which it now is. And that was very distressing for us, because, of course, you don't see what's going on until, a little bit a day or two later. It's kind of like a gaslighting kind of thing. So this is very problematic then, because before the election, both issues were denied judicial scrutiny, constitutional adjudication. And then after the election, it appears due to a constitutional... and the question is, was this known to the people that put me? Was this known to them that if I was put here, the worst I could do was... was that known, or was it engineered? I mean, that probably is not something that we'll be addressing, but it is an ethical issue. But there are battles one should fight, and battles which I'm not fighting. That's not a battle I'm fighting. I'm not fighting the ethics of doing what was done to me. It was like a chess game, and I was the fall guy, because I was the one that was put on the eve of the election. So that's not the issue that I'm interested in fighting. The interest I'm hearing here is the constitutional issue that resulted from this process. And even the time frame itself, no matter when it was heard, would was there enough time anyway, once the case was highlighted, for the issues to be addressed in a way that both could be addressed by the Constitution, given the way the Constitution, Article 12, is currently what's in Article 12. And if that so the full impact of what happened could not have been seen while the process was ongoing. And once the impact became clear, the process was already closed. There was no clear legal point at which the issue could be examined or decided. Well, there was before the election, but there is usually a lot of constraint before the election, these kind of cases. And then after the election, because of the way the Constitution is, one of the key points could not be adjudicated upon, even though it nearly automatically follows from the first one. So can a constitutional system function properly? So I'm not bothering about the ethics or anything like that. That's not a you have to pick your battles. I'm not interested. That's not what I'm interested in. It's very upsetting, but I'm not interested in it. You feel like you were just a pawn. You were used as a pawn in a game, and justice should not be a game. Can a constitutional system, but I can still ask this question, can a constitutional system function properly if a constitutional breach can occur but cannot be examined at any stage when it becomes legally visible? It could have been examined, but there seems to be a widespread problem. So if a constitutional pathway exists on paper but can be neutralised in practice, and if that neutralisation cannot be reviewed because of timing or procedure or other matters, then we are left with a constitutional blind spot. And that blind spot does not stop with one election. This is the point here. That they could say, oh, sure, it's just an election. Forget about it. There's no mention in the newspapers. Nobody wants to talk about it. Universal silence. So it never happened. This never happened. It did happen. It did happen. Sorry, it did happen. It's inconvenient, but it did happen. If this issue is not examined, in my opinion, by the courts, it sets a precedent. It signals that constitutional mechanisms, especially those designed to allow participation outside party structures, can be rendered ineffective without judicial scrutiny. You'd imagine that would be something the separation of powers would be very interested in addressing, because it's unprecedented, I suppose. So it's new. But the consequences of not addressing it could lead to really bad precedent setting. So this is the issue here. This has consequences for future presidential elections. It has consequences for other electoral and constitutional processes, and it raises the possibility that similar issues may already have arisen in the past without being examined. Now, I'm not I'm a mathematician, but I'm just envisaging that this is not unique to this situation. But it's unique. This is probably the first time it has ever happened or been raised in a presidential election process context. This is not about outcomes. It's not about personalities. It's not about politics, personal grievances, anything like that. It's about whether constitutional safeguards work in practice when they matter most. A constitutional democracy depends on more than written rights. It depends on access to justice, my favourite topic, access to justice, and I have my own views on how our current system is unfit for purpose completely with regard to access to justice for those who need it most, particularly the squeezed middle, everybody, and also what that justice should mean in practice. I'm saying we need to redefine justice. I mean, it's a huge thing, but I've written a number of papers about that, but that's not for this today. It depends on courts being able to examine serious constitutional questions when they arise. And I suppose that means there needs to be a time limit, or some kind of a time frame in which they can do that. If certain constitutional questions are structurally incapable of being decided, then constitutional protection becomes incomplete. This is why this matters. This is why scrutiny, in my opinion, by the courts, ultimately by the higher courts, the Supreme Court arguably, should be considered as necessary. Not to assign blame, but to clarify whether a constitutional vacuum exists, which I believe it does. I mean, I can't see that, I can say I'm part of that, the consequences of that vacuum, and if so, how it should be addressed. Ignoring this issue does not preserve stability, it preserves uncertainty, and actually it weakens the separation of powers. It says we can only do this, we can't do that. This strengthens it if they do this, if they actually address this issue. I mean, I don't have the answers because they are all the experts, but I can bring the question. I haven't done anything yet now. I'm still trying to figure out how I'm going to put it, if I do put it. Ignoring this issue does not preserve stability, it preserves uncertainty. Ensuring it would strengthen constitutional clarity, reinforce the rule of law, and ensure that constitutional roots operate in reality, not just in theory. This is the question this last video for the moment raises, and it is a question that, in my opinion, deserves an answer. And if anybody has the answer out there, I'd be delighted to hear it, and what they think should happen. So if anybody can understand the complexity of this and write down what they think should happen here, of all the contributors, the many contributors who have stayed with me, because it is very complex, really. So there are some very smart individuals, contributing to this. Very, very smart, extremely clever, because it's very complex. I mean, it really is. I mean, we're addressing very difficult constitution issues here, and even it taxes my brain to try and figure them out. It really it's very taxing, mentally to try and address the complexities here and spot the blind spots. It's very, very challenging, but very mentally, especially when you're kind of in a fight against time. Not unlike the previous battle against time, and I can see now, it's getting a bit clearer. So we're approaching more and more clarity about the constitutional issues that are still need to be addressed here. Thank you.